Hello, my name is Muhammad Alam and I am a senior lawyer and owner of this law firm, Alam Law, your lawyer in respect to your injury matter. In your car accident, as you know that you have potentially two kinds of claim. One is called accident benefit. The second claim, if you are not at fault, it's called tort claim, a negligence claim against negligent driver, a lawsuit that has been started so you can get compensation for your pain and suffer and other losses. Now today I'm going to talk about insurance medical examination and defense medical examination. So in your accident benefit, insurance company is entitled to send you to their own medical assessors to assess you whether or not you are entitled for certain benefits, for example, income replacement benefit, or you continue to be entitled because insurance company can assess you one time that you are entitled, and after few months they can also seek opinion from their doctors whether or not you continue to be entitled for income replacement benefit. Similarly, insurance company once your treatment plan is submitted, your doctor or your physiotherapist and chiropractor believe that you require ongoing treatment, insurance company can submit that treatment plan to their doctors to get an opinion, and that doctor may choose to see you in person to assess your needs. The second claim, which is called tort claim, which is your lawsuit, the other lawyer or other party's lawyer being backed up by insurance company, they can also choose you to send you to their doctors or their experts to provide a medical opinion. Like we choose many doctors and experts and obtain medical opinion and reports to support your claim. Both insurance companies and other parties lawyer in tort claim, they are also entitled to do so. But most importantly, you have to understand the purpose of this defense medical or insurance examination. It's that they have been retained by insurance company or other parties lawyer. These doctors, although they should be independent, they should be neutral, but I often see that they are biased. They're not neutral. Their reports are more favoring to insurance company. They highlight things that does not go to your favor. They will not leave any opportunity not to include the information that is available that they believe hurts your credibility. So you have to be very careful when you attend these examinations. First of all, when you receive these notices or email from my office that you have to attend an examination requested by either insurance company or other parties lawyer, you make sure that you diarize and you do not miss the medical appointment, because if you miss, you may have to pay cancellation fees, because these doctors are expert and their cancellation fees could be anywhere in the range of $1,000 to $1,500. So make sure you do not miss the medical examination. And also, if you believe that you require interpreter or transportation, you make sure that you email back to the staff who has sent you communication about these assessment. So a transportation and an interpreter is being arranged for you to attend this examination. The other important thing that I would like to bring to your attention, that you have to be very careful when you are speaking to these doctors, and information that you are providing, it has to be very accurate. Otherwise, these doctors, as I said, will not leave an opportunity to write a report or provide an information that may compromise your credibility. One example I generally give to many of our clients, that if after the accident, you're telling this doctor that you were unconscious, but unconsciousness is also a medical term. Sometime I know that you really do not exactly mean that you are unconscious, but most of the time I've seen people use this word in front of a defense medical that you are unconscious for 5 minutes. Well, this doctor has also already reviewed your paramedics who attended the scene, their report, hospital report. And if these two medical reports notes that you were alert and you were not unconscious, and you're telling this doctor that you were unconscious, this is an opportunity for this doctor to write in his report that you advised him that you were unconscious. And now what will happen? When this report will be presented to defense counsel will try to take this opportunity to discredit you or challenge your credibility at trial, that you have lied to this doctor or you have lied to these few doctors, although you did not have any intention to lie. But anything that you say, you have to be very careful. For example, you've not been working for the last 3 years and now you have gone back to work. You went for examination for discovery. You have told defense counsel that you have returned to work since last year or last December. You make sure that you don't say anything other than what you have testified at your examination for discovery to this doctor. Because if you tell this doctor that you have not gone back to work, then that could also be a problematic, because if this doctor writes that you have not gone back to work and this report goes to defense counsel, you are giving another ammunition to this lawyer to challenge your credibility. A few other examples that you have to be careful, because in these medical examinations you are being watched and observed. How you are walking, how you are sitting, what are you doing. So let's say it's a start, your observation by these facilities starts when you enter into their facility. Even sometime when you park your car, whether or not you were using any assistive devices from your car to the facility as you were entering. Take for example that you have cane in your hand, you have not been using cane, but as you enter to the examination room or as you enter to their facility and you started using cane, and if the facility knows that you were not using cane while you were sitting outside or while you're moving from your car to the facility, that is also something that may challenge your credibility or compromise your credibility. So I always suggest that if you are not using any assistive devices, you don't have to show them, you don't have to impress them. We understand that you're living with pain, but you don't have to impress them at the examination that you have been living with pain. You can tell them that you're feeling pain, and on occasion you use cane, but not all the time. That is the accurate information. So that you have to be very careful. Similarly, if you have pain in your shoulder and you have been living with this pain, when you're sitting in the examination room, and if you keep rubbing your shoulder, this doctor is also observing you, and he will be writing notes. And I bet you these doctors could write their private comments to defense counsel that this plaintiff looks like more focused on pain, and he's behaving that he has pain, whereas when he was sitting outside he was not rubbing his shoulder, but in an examination room he continued to rub his shoulder to show me that he has pain. You don't have to do any of those things, because your medical records speak to itself. Your family doctor has been writing that you have pain and you're living with chronic pain, you've been taking medication, you're seeing other experts. You don't have to show that to this doctor, but you can provide information. You can tell him how you're living, you can tell him what medication you have been taking, you can tell him that you have been living with pain, but unnecessary do not try to show him, because that does not goes to your favor. The other information, that there are times that some of these doctors, although they should be, they are professionals, they are medical professional, they should not be, they should have sympathy when they are seeing an injured person. But I've seen there are some medical assessors who are rude, and if they are rude, you can tell them or confront this doctor that they should be respectful with you, and you should also send us an email about this doctor's behavior if you felt he's outrageously behaving not respectful, because those doctors then tends to be adding information which may not be true that you have provided them, and I have seen those reports. So I also suggest you, if you have doubt about this doctor who you felt that was not really professional or acting in a good faith basis, or was not professional while they were conducting examination on you, email back to your case manager, email back to the staff who send you the medical examination detail. You can also ask us to provide you a copy of the medical assessment report, so you can go through that medical assessment. You can also highlight or scan an email back to us. Let's say if you find something which is not true, or which you have not advised to this doctor. Let's take an example. If he writes in his report that examination conducted for 1 hour and 30 minutes, and you know that you were only there for 30 minutes, that is something that you want to bring to my attention. You also want to bring to my attention if some information which is factually incorrect and you have not told this doctor, let us know. Other than that you have to keep in mind, these doctors have their own motives. And again, I'm not generalizing. All medical professionals are retained by insurance companies or defense counsel. But I have seen some of these doctors go well beyond and start acting as a hired gun for insurance company or defense. If you have any other concern that you would like to speak, send us an email, and we'll be happy to schedule a phone call or an in-person meeting with one of our lawyer. Again, dress appropriately when you're attending these medical examination. Know which medicines you have been prescribed, which medication you have been taking, what treatment you have been receiving. Those informations are important to share with this doctor. Thank you for watching, and again, if you have any other question, feel free to reach out to us via email, which is the best way to communicate these days. Thank you.